Hi, I'm Mark Feldman. I'm a professor at Peking University's School of Transnational Law in Shenzhen. This video is part of the ITA Academic Council's What I Am Working On series. I've served on the Academic Council for several years. I've been working on dispute resolution in the context of China's Belt and Road Initiative. These are Chinese-funded infrastructure projects that are now occurring on a global basis. The increase in volume of these infrastructure projects already has and will continue to give rise to an increase in volume in infrastructure project disputes. And so I've been looking at dispute resolution for this emerging regime of disputes relating to Belt and Road infrastructure projects. I have a working draft that is called Connectivity and Decoupling, China's Belt and Road Dispute Resolution in a Fractured Trade Environment. And this working draft looks at two competing forces in the global economy today. One is the force of connectivity, which is a key policy motivation behind the Belt and Road Initiative to advance connectivity, which is broadly understood to include cooperation between institutions, cooperation between individuals, and Belt and Road connectivity extends to dispute resolution. There are many opportunities within dispute resolution to advance connectivity. These would include cooperation between arbitral institutions, both Chinese and foreign. It would include greater enforceability of domestic judgments in the form of the development of recent Hague Conventions on the enforceability of judgments. It also includes the development of a China International Commercial Court, which has tribunals in Xi'an and Shenzhen, which now has the opportunity to interact with other recently developed international commercial courts in Asia, in Europe, and the Middle East. So all of these developments allow for, within a dispute resolution context, to advance connectivity, advance cooperation between individuals and institutions. But at the same time, we have a competing force of decoupling. So this would be a sharp decrease in the level of economic interdependence between, in particular, the US and China. And so for states around the world, they now need to navigate these competing forces of Belt and Road connectivity and the forces of decoupling, which are encouraging separation. And ultimately, I conclude that given the advances in connectivity that are occurring, in particular in a dispute resolution context, as well as China's active role more generally in rulemaking and institution building, in my view, the risks of major economies detaching themselves from China as part of a larger decoupling movement, I think those risks are sharply reduced by the active rulemaking and institution building that China has been engaged in, particularly over the last decade. So again, that is a working draft on connectivity and decoupling. I will be working on a larger project, also looking at Belt and Road dispute resolution with Professor Maniruzzaman at the University of Portsmouth. We will be looking at an emerging Belt and Road dispute settlement regime, which includes very different forms of legal systems, including common law, civil law, Islamic law systems. Also includes a variety of forms of dispute resolution, ranging from domestic litigation in international commercial court, commercial arbitration, investment arbitration, mediation. And so we will be looking at these various forms of Belt and Road dispute resolution occurring within different legal systems. And in particular, we will examine in particular detail the potential role of a China International Commercial Court in terms of its ability potentially to interact with other international commercial courts, which, as I mentioned, have recently emerged in different regions, Middle East, Asia, and Europe. And we also will be looking at the potential role of the Asia Infrastructure Investment Bank, which recently has expressed particular interest in dispute resolution, and certainly thinking about multilateral development banks generally. We can view the AIIB in the 2020s as perhaps not unlike the World Bank in terms of how the bank is situated, not unlike how the World Bank had been situated in the 1960s when developing the ICSID Convention, which of course was aimed at encouraging cross-border flows of investment capital, private investment capital. Now, with the emergence of a Beijing-based AIIB, Multilateral Development Bank, there is certainly the potential for that Beijing-based bank to play a similar role in advancing dispute resolution, which could in turn encourage flows of cross-border international private investment. So thanks again to the Academic Council for this terrific initiative and the opportunity to participate.